Now let's move on to the next concept, fraud. Fraud exists when it is shown that a false representation has been made knowingly or without belief in its truth, or recklessly, not caring whether it is true or false, and the maker intended the other party to act upon it, or there is concealment of material facts. The intention of the party making fraudulent misrepresentation must be to deceive the other party to the contract or to induce him to enter into a contract. According to section 17, fraud means and includes any of the following acts committed by a party to a contract. First one, the suggestion that a fact is true which when it is not true, and the person making the suggestion does not believe it to be true. We call it as suggestion falsi, that is making false suggestions. Second one, the active concealment of the fact by a person, which is called as suppressio veri, that means actively concealing the fact where it is his duty to bring out the true facts. Third one, a promise made without any intention of performing it. Fourth one, any other act fitted to deceive. Fifth one, any such act or omission as the law specifically declares to be void. Let's discuss the essential elements of fraud. First one, there must be representation and it must be false. So any representation made, if it amounts to false representation, then it amounts to fraud. In Peak versus Gurney case, the prospectus of a company did not refer to the existence of a document disclosing liabilities. This gave the impression that the company was prosperous. If the existence of the document had been disclosed, the impression would have been different. It was held that non-disclosure of information amounted to fraud, and anyone who purchased shares on the faith of this prospectus would avoid the contract. The second essential is the representation must relate to the material fact which exists now or existed in the past. Third essential is the representation must have been made before the conclusion of the contract with the intention of inducing the other party to act upon it. Fourth essential is the representation must have been made with the knowledge of its falsity or without belief in its truth, or recklessly not caring whether it is true or false. Fifth essential, the other party must have been induced to act upon the representation or assertion. A mere falsehood is not enough to give a right of action. In Smith versus Chadwick case, A bought shares in a company on the faith of a prospectus which contained an untrue statement that one Mr. B was a director of the company. A had never heard of B, and therefore the statement was immaterial from his point of view. A's claim for damages in this case was dismissed because the untrue statement had not induced A to buy the shares. The sixth essential is the other party must have relied upon the representation and must have been deceived. If the representation does not come to the notice of the party, it cannot be said to have misled the party because it does not lead that party at all. Seventh one, the other party acting on the representation or assertion must have subsequently suffered some loss.